just to let everybody know how actually impressed I am with what we've gone over and how more impressed I am with how difficult this topic is, this subject is. It just seems like every time you pick at this onion, there's another thing in those layers, and this group has done a great job. I want to thank my property assessment division and TPR division people for all of the efforts they put in. Great efforts on keeping us all prepared. Between us and the governor's property tax advisory committee, this has been a busy season for these guys, and they've really done a great job, so I really appreciate it. With that, I'm going to recap kind of what a couple of decisions we made last go round, and then kick around a couple ideas with you, just kind of my cogitations that have been had with a few of you and some of my own crew here. Basically, to recap, we as a group decided to pursue eliminating the automatic classifications for non-qual and for agriculture. And I think that's a fairly good decision. I'm sorry, I was kicked off without you. No, you're fine. As I kind of stew on that decision, now the hard part, it's easy to decide what we wanted to do. Now how we're going to do it. And I want to reiterate that at least my goal in this committee is that we don't do something that has some unforeseen consequence to some innocent Montanan. If we do something that harms one that we didn't mean to, then we fail in my book. So I might sound like the naysayer over and over again, but I think our job is to be very, very, very careful in how we proceed here. So on that note, one of the things that I've been cogitating on, and in fact, John and I had a really good discussion the other day about minimum numbers on things like application. And we need, if we're going to look at minimums of anything, I really hope we discuss those numbers and talk to a lot of people before we go anywhere with that. I did a bunch of math myself, and the minimum number that I think would be reasonably safe sounds ridiculously low. And then I did some math on the lease I've got and went, my God, that's ridiculously low. So I did it at John's prompting because I actually hadn't done the math. And I'm really concerned about that we don't get too aggressive on what we think somebody should be making off their agricultural enterprise or their agricultural land, because this is harder than you think, or than I thought, actually. And I'm in the business. So on that note, I'm going to step back unless anybody has any opening comments or questions for me as we proceed. And if not, I think it's on to Scott, isn't it? With decision-making criteria. Go ahead.
Just a question about the discussion today. Will you or your staff be able to talk about the impact to the department for that change in terms of man-hour cost? Like, what's this going to do for you guys to be able to implement this?
We can go ahead, Robin. I'll let Robin get that.
We do have some ideas to throw out at you in regards to that. We haven't completely calculated any kind of fiscal note or impact or
I wasn't
any
going to use
kind
that
yet.
dirty word.
Yeah. But we do have some ideas that we think could help us eliminate the need for a lot of additional FTE.
Sure. That's kind of what I want to know. So if that's coming up, that's all I'm curious about.
Anybody else got anything they want to raise before we move along? Go ahead.
You made the comment that you hate to attach a number that's not reasonable, depending on who's involved in what they're doing on their ag operation, but by creating a AUM benchmark, haven't we already done that?
That's a very good question. On non-qual for sure, right? I think you're right on non-qual. I was thinking, and I should have been more clear, I was thinking more on the minimum on the 160s plus.
Yeah, okay.
And especially what the conversation John and I had, and I really appreciated John's phone call, is you started kicking that around with me about your lease of grass. It depends on what part of the state, what that grass is worth. You know, if you're up there at Wolf Point, the grass is worth $40 a cow. or more. Ingemar might be a lot less. So there's some things we need to think about there, and I was thinking more on the 160s plus,
Mhm.
because you're gonna have to do something with
Right.
on-call.
Right.
But even so, I don't wanna be party to something that puts legitimate individual out of business or under undue hardship, because I really think my job in this is to try to take care of the people that pay my wages, and that's, I take that to be serious, so. But thanks for clarifying that. Anybody else before we let Mr. Big kick off here?
Well, I wanted to have us think about this, and I would like to come back to this later on today. I've got some notes up in my office, but the reason that I wanted to have this discussion among us or have you think about it, maybe you thought about it, but what are we trying to accomplish here? And what are we hoping to come out of this? What should be the criteria that we proceed by? For example, if we come to consensus here, that's one thing. It's another thing to get a bill passed. And so is doability of an idea one of the criteria that we should be considering? And so should we be thinking about sort of an honest assessment of the political reality of some of these ideas? The point of bringing that up is that we can put together a great plan, great ideas, great consensus here, and we'll abjectly fail if we don't really think about the doability of that. And there's also another criteria is that I've thought about is there's going to be winners and losers. And are we altruistically trying to make sure that only people that deserve this classification get it? Or are we trying to minimize the damage to people that would get caught up in whatever we come up with and unduly have it removed from them? So those are the couple of things that I was thinking about. But I would like to revisit this if we could, Mr. Chair, because I've got some notes that I didn't bring with me this morning. So. But I don't know if we have other thoughts about those sort of things. Maybe some of you have thought about what are we trying to accomplish here. Would welcome those thoughts. I know there's some deep thinkers here.
Before we move on from that, and I apologize for interrupting here, I want to introduce to the gang here Tyranny Mosing, who saved my bacon by taking over a temporary management job of the Bozeman area. And we had, for lack of a better word, a disaster there. And she stepped up out of nowhere and really righted a ship that was possibly sinking, but certainly on fire. And I can't speak enough of how good she is. She's moved to the Helena office, to our central office now. And to show you how old I'm getting, I used to play football against her dad. I don't feel that way. Maybe I look. So I just want to introduce, this is another one of our upcoming overachievers. She's just done an awesome job with everything she's touched. So thanks for coming here.
You have a very young dad.
Nice save. So Scott, were you raising the question about how we should be going forward, or did you want to address that?
Well, I just think that, so we've heard of a lot of ideas out there. We've kicked around a lot of ideas, but at some point, if we, I think our goal is to have something to present to Rick by midsummer, right? And if it's a good enough idea, we would like them to consider taking it on as a committee bill, one. So when you start with that end in mind, we've got this meeting and then probably another one in a month or something like that. We need to narrow it down. So how do we decide what is the criteria that we should be, because there's pros and cons to any of these ideas. The administrative expense and effort is another criteria we might throw out there. But what are the criteria that is going to guide our decision-making about what we select? Is it 100% consensus?
Can I ask, go ahead, Senator, and then I'll follow up.
Well, you're bringing up some good points here, and I think that once we go through and identify and clarify how we'd like to proceed, we should probably take some time right after lunch to identify the arguments against what we're discussing, and probably identify which groups are going to come in and lobby against any type of bill that we put forward. Because that's where we're going to find out at what level we're going to be trying to do a PR job on whatever we come up with, to show that it's a consensus for the majority, and it incentivizes the purpose for which we're addressing.
I think that's well said. I do have a question for you guys because, and I'm just gonna ask it honestly, am I crazy am I out of step with what the group's feeling is on my concern about the collateral damage? Am I overblowing that in your minds? I will not be offended if anybody disagrees with me. Trust me, I've practiced law for all those years. I got disagreement all the time. But that has been one of my biggest concerns. And it kind of goes with what you're saying, Senator, but I might be out of step with consent. I might be the only guy that's maybe primarily concerned, because I have been primarily concerned with collateral damage here. But if I'm the only one that's primarily concerned with that, that's cool. I'm not offended by that at all. But we kind of need to think about that, right? Don't we, Scott?
I think,
Well, go ahead,
let me
Roger.
just interrupt real quick. I think one of our presentations today is some income requirement alterations that is interactive, so that we can change those numbers and we can see what they look like, and we can see what the average producer, the average productivity level requirements are, as well as part of our presentations today. So that might help identify what that income change would look like, and then we can discuss that further too, if it's doable or not.
Okay, that sounds good too. Even that notwithstanding, what's the goal, right? Go ahead, or let me process his hand up first.
Well, I think, to me, we're looking at tax law that is structured with classes for a specific purpose. So the question is, are we willing to maintain that concept, right? Because it's exclusionary, right? Some people are gonna get it, some people aren't. And why do we have this classification? What is the purpose behind it? My assumption would be is that we understand ag's important. It has a very fine profit margin, or, hopefully a small loss margin in the process, and we're trying to support that particular industry. And if that is the purpose behind this classification, then to me, I think we should look at it at that level. Is this really functioning at that? Because everybody wants it. Some people are gonna get cut out, but that's the point. Otherwise, why even have it? So, and it may be, maybe it's untenable. Maybe we're gonna find that there's so many people that don't, that are gonna fight it, that maybe it's a problem. But my gut feeling is those folks that are truly purchasing, especially the 160 and up, and not producing ag of some sort, is a small number. Oftentimes they have a lot of money, but the whole function of giving, and maybe I'm a little biased because I'm in a county that got their mountain bought up by a number of very wealthy out-of-state people that have no interest in ag. And I see it personally with the producers in our area that lost leases, lost opportunity to utilize that, the land that's there. And so if there's a purpose behind it, I guess it's to say, you can qualify for this if you actually are engaged in production agriculture. Devil's in the details, I get it, but I still feel like that needs to be the point. And if it comes to where we can't define it, then I guess we can't, but I think that needs to be the focus and the purpose, is to determine if we're gonna have an ag classification to give an incentive for production of ag, then it needs to fit that. Otherwise, why do it?
In response to both of your comments, I would say our overriding objective is a fair and equitable tax structure that's administered uniformly. There are going to be winners and losers. And when you talk about somebody being adversely impacted, I would qualify that statement and say I wouldn't want any ag producers to be adversely impacted. But there are going to be people who aren't using the land productively that may well be adversely impacted. We saw data during our last meeting of sometimes even adjacent but very like parcels that were treated very differently under our current tax structure. And to me, that's not a tenable situation. So I don't know how we blend those. I think we will have, as the senator referenced, a number of people who might line up at the door when we present a bill. But if in fact we can come away with something that can be fairly administered, that doesn't hurt ag, people that are legitimately engaged in ag, then I think it's worth pursuing.
All of you said it way better than I did, by the way. Go ahead.
I don't have any concern with the people that have large parcels, large tracts of land. You're either on the bus or you're not. I have more of a concern with the people between 20 acres and 160 who are legitimately engaged in an agricultural endeavor. Those are the people that I want to make sure that we don't have unintended consequences with.
Kind of like the guy that comes to mind is, and I spaced his name, that talked to us once or twice. on-
Mr. Smith from Lewistown.
Correct.
Mhm.
He comes to mind.
Mhm,
And
yeah.
actually, when John and I were talking, you throw around, and this is on 160s and over, a minimum dollar per acre.
Mhm.
Well, it sounds like $10 an acre gross income sounds pretty cheap, right?
Mhm.
I'm looking at a lease right now that's less than that. To lease it from another party. John had an example of an individual kind of somewhere out in the hills out there that was leasing grass for less than $10 an acre
Mhm.
overall, right?
Mhm.
Sounds cheap. Until suddenly I actually sat down and did some math.
Uh-huh.
And those are the collateral damages I don't want to hit, right? That one scares me because there could be 100 reasons
Right.
why.
Well, one reason that comes to mind for those low lease rates on large tracts of land is it could be a familial relationship. I'm gonna lease this 10,000 acres to you for $5,000 because you're my kid and I want you to succeed.
Right. Or how about you got 10,000 acres with one water hole?
Yeah.
I mean,
Yeah.
Those exist out
Yeah.
there, right? So I'm gonna lease you the whole place, but you're really not getting cows to the far end of 10,000 acres, if there's one water hole on one end.
Mhm.
But you've got the whole place, right?
Right.
Those are the ones those are those one-offs, those things that really started making my hair stand up, all these one-offs. And these are the ones that I would call the innocent. They're honestly, they might not be getting rich, but they are engaged in agriculture, whether they're leasing or
Right.
have starved dead cattle, for all I know. But those are out there too.
Yeah.
Sometimes it's mine. Bonnie had something she wanted to raise, and then we can move along, unless anybody's got more comments.
My one thing was, that I want to say is that I've been working in the central office for over a decade, and these same things have come up every legislative session. In 2017, we actually took 4 bills that were Revenue Interim Committee took to the legislature. The one bill, which was to eliminate non-qual, did not even make it to the first hearing. And we had at that time brought in all the different ag groups and had talked about these and had several meetings before we went to the Revenue Interim Committee. So there was a working group at that time. And I think, I'm gonna say this, Montana is the only state with that type of a classification, the only state in the union. So I really feel it's unfair because everything else is about use. Non-qual just sits up there on top of it as a size thing, and it doesn't make sense. Causes a lot of inequity. My concern, and because I'm thrilled with all the things I've been listening to, et cetera, that you guys have been doing, how do you make that go forward? And there's a lot of different groups here. I don't know if it's legal, so to speak, to do some PR within your groups and get the word out so that there is a push from your constituents to move a bill forward. so that you don't do all this work and then have, get a bill put together that doesn't even make it to you. So that's what I have to say.
Yeah.
Go ahead, Marcus.
Yeah, I, just going back to your original question, what you've been wrestling with is what I've been wrestling with, is how do we put something forward that does not have unintended consequences for folks. And I like what you're proposing. I'm interested to hear more about what your staff thinks about this proposal. My thought about public policy is much like steering a ship. You make small adjustments and you get big outcomes, right? And this seems like a small adjustment that maybe has the least amount of like seismic shift across the state. Like this could actually be, from all the things we've talked about, something that's very positive, that addresses some of the concerns we've had, but also doesn't have this massive unintended, impact to people that we don't want to catch up. So I'm interested to hear more about kind of your analysis of what this would do if we were to put something like this forward. I also think, going back to, I think something Scott said, this we could probably sell easier than some of the other ideas that we've had out there. So
When you say this, are you talking about removing the non-qual?
the auto qual.
Got the auto for both.
Yeah,
Gotcha.
what you talked about, yeah, I think, if we were to go to folks and try to sell a lot of these things, then we get a lot of pushback. But I think just saying like, you need to re-up each year and qualify each year, that I think is an easier sell than, let's say, removing non-qual. That I could see being very contentious, so. Yeah.
Scott, go ahead.
Just to tag on to that. If we think, so this is a department-led initiative, it's different than the governor's initiative. And we want help. We have enlisted you all because you're the experts and you represent the impacted constituencies. We don't have to do all of it at once. We think that this is a useful process. And if you guys all feel like this is a good use of your time, there may be an analysis that says, what can we do, to your point, to make to get something accomplished, get it done, and then we continue the effort and take another bite of the apple. We don't have to take the biggest swing at the big picture necessarily at this time. So that's the practicality side of this too.
I might piggyback on that and say we don't need to identify a single standard. Maybe there are multiple options that would allow a producer to qualify. We've talked about Schedule K, we've talked about minimum income levels, et cetera. So thinking in terms of casting a broader net to allow people that are in production to qualify.
You asked about our goals. I guess my goal, and speaking to my constituents and other producers, they're willing to do this and to show productivity if they can see a benefit from it. And so I guess that's really the goal I'd like to see, is that the tax burden be shifted, If we can see a tax break, this is worth doing. If we don't see a tax break from it, really, what's the sense, from our level? So if we can shift that tax burden from productive land to those properties that have been taken out of production, then people are very willing, at least the people I've spoken to are very willing to have to prove productivity. But as long as there's that benefit, down the road.
I mean, you might get two benefits, but some of the benefits it's not gonna be even, right? In Ross's County, there's a whole bunch of big places that have been taken out of production. And if you shift it in that county, you might see a better tax benefit to the real producers than say a county that didn't have a bunch of property taken out of ag production, right? So across the state, you might see Fergus County, just as an example, with a bigger tax base, thereby technically lower mills. But pick a county that may not have that much elk hunting, Sheridan County may not be selected. They may not have any recreational ranches, or not to the extent especially that Fergus really is tough, and there's some others too. So some guys and gals are gonna see a better, if something came out of this, it's not gonna be an even distribution probably, it's gonna be a county by county or taxing jurisdiction by taxing jurisdiction change if there's a benefit.
Yeah, I agree with that. I think the eastern side of the state's not gonna see the benefit as the
As
central
much.
part is the west to the west.
Yeah.
It's just true, and I don't see our county, I don't see myself receiving a huge benefit in this. Golden Valley County's not really being bought up. I mean, it's coming and it's happened a little bit, but Fergus County, on the other hand.
Just wait till
big
there's
time.
suburban buildings, then you'll think differently.
But I mean, I've spoken to a lot of other producers and I have gotten no pushback. People think this is a good idea. And the people I've talked to are very willing to have to prove that productivity as long as it's not a difficult task.
And as long as it's not constitutionally controversial. You don't wanna
Good point.
treat people, you don't wanna treat people differently, you know, but we all see the benefit of trying to capture that lost production for all those counties who have that experience, like Lewis done that. So it makes sense. My county would be one of those that would not benefit either. But one of the other benefits of proving your production is maintaining your ag classification, like either you do it or you don't.
I'm hearing some really good PR comments already. And particularly with ag producers, this is going to add integrity, I believe, to the classification for productive agriculture. And I think it also will go toward alleviating some of the pressures that we have on tax revenues or for tax revenues.
Good, well, all I'm hearing is good about, especially, you know, it's really the producers that are the ones that might push. And as a producer, I'm looking pretty darn close at this.
Yeah.
Personally, but it's nice to know that the parties here that are representing, I would say, more greater than 160s than not, are on board, right? Because I haven't heard much, but I don't go out in public all that often anymore because all I do is talk to the most unpopular person in state government at the moment, so maybe next to Paul. So it
Mr.
sounds like-
Speaker, we have a question from Mr. Story online.
Go ahead, Bob.
Well, I just following the discussion and I think, you know, the difficult part of qualifying for ag is going to be those small property owners. And I know, Cindy, you've got a lot of those as membership in Western Montana, but you know, they're a different kind of ag. I mean, they are ag, you know, they've got equipment, they've got livestock, they do different things, but you know, they're not big ranches. And so that's gonna be the difficulty, I think, in this endeavor of dealing with who's ag and who's not. You know, it's pretty easy on large ranches, and that's pretty easy, I think, to figure out, well, not easy, but it's doable to figure out the recreational ranch properties that, you know, the people that bought places, those people, once they find out, are going to figure out how to qualify anyway. They'll do something to qualify. So it's really going to be, you know, like the guy, Cindy, that showed up yesterday at the meeting, and, you know, he had enough acres. He thought he qualified AUMs, but the department said he didn't. And, you know, that's something that I'm sure people are looking into, but those are the people that are gonna have difficulties with this. You know, that's where the unintended consequences will be, I think, is those type of people, and there are probably a significant number of them. I guess we saw those numbers at some time during our operations here, but how many of those under 160 acres or around 160 acre people there were, but I think that's really going to be the issue. Thank you.
Well, and Bob, that guy that appeared yesterday is a frequent flyer on my cell phone, my email, everywhere. A lot of the facts espoused yesterday weren't exactly the facts, but yeah, he's certainly one that thinks he's being picked on, for sure. And sometimes your perception is your reality.
Yeah.
But that, yeah, facts are a little bit different than as portrayed. So, but your point's well taken. When you say smaller properties, that's a relative term, right? In the Flathead, 160 acres might be a big deal. 160 acres of flat willow, you'll starve to death. Right? So small tract is in the eye of the beholder and also in the eye of the carrying capacity or whatever it is, your productive capacity and where you're at. So Bob, I got a question for you. In your mind, what is the small property? Is it a sub 160? I just wasn't sure we were talking about who's small and who's not.
Yeah, I think, as you well know, it's all location dependent, right? You know, but yeah, I think it's those people in the, 40, 80 acre range that are either non-qual right now or they are qualified ag, but depending on what you use for qualifications is going to be the issue. And that's where I think you really have to kind of, it's been talked about before, look at income per acre or something like that so that you, and then I think you really need to get back to something that was discussed a couple sessions ago about a minimum size to even qualify for ag. So you don't have backyard gardens and 1 acre tracts and stuff like that be in there. But I mean, you all know the cherry orchard issue is kind of like that. You create a situation and people find ways to take advantage of it.
Well, it's written, as I understand it too, the cherry orchard thing, at least in my time at the Department of Revenue, has always been a big deal. But as Wally Congdon was standing here the other day talking about, there's a lot more out there that sometimes we don't think about that kind of look like the cherry orchard thing, whether there's somebody with commercially growing herbs or, he had quite a number of interesting examples that actually frankly hadn't gone through my mind as I sit here and think about it, and you pay me to think about stuff like that. I missed a lot of those things. But Wally brought them up, and that's why we have these, right? So it's more than just the cherry. It's how do you not cut out the person who's actually got a commercial ag enterprise growing parsley, right? I hadn't thought about parsley, but it just, like I said, this onion, you just keep picking at it. There's more stuff under there. So I don't really know where to go after I said that, other than to follow the agenda and figure out where we go from there.
So
Is Robin up next?
we're gonna talk about the current agricultural application and all of the required information that's included on that anybody has to provide us to be qualified ag. So Amanda's gonna tell us all about that.
And I gave everyone a copy of what our current application looks like. You can find it out on our website also. And along with that, I attached behind it the MCA that we use and the administrative rule for eligibility of land for valuation as agricultural. And then administrative rule 4220-620 is the application and classification requirements for agricultural land totaling less than 160. I wanted to walk you through the ag application. Like, this is for people who have less than 160 acres. This is what they're handed to determine, for our department, to determine whether or not they qualify. Some of it's pretty self-explanatory. There, your required information. Need to know who you are, how to contact you, your geocodes. Your geocode is your property identifier that the state uses. It's about 17 digits long. And then if you go back or down a little bit further, we need to know how many acres you're going to be using in your agricultural operation. So if you have an 80-acre parcel and you're only using 5 of it, that's what we want to know, like how much, like it kind of gives us an idea. Yes, we can look at your record and determine that you have 80 acres, but we're wanting to know what you're using in your ag operation. Then we want to know, do you have multiple parcels under this ownership? Because just because you have a parcel of 80 acres in one town doesn't mean that you can't have another parcel in another town under one owner, under the same ownership. You're also using as an integral part as that operation, using them together. So that leads to, we wanna know if it's, they're in the same county. Because again, doesn't need to be in the same county for it to be qualifying integral parts of an operation. So again, you can have a 5-acre parcel in one county and your 1,000-acre ranch in another county, but that 5-acre parcel you're using as your holding parcel for your cattle for the trucks to come pick it up. It's an integral part, but it's only 5 acres. So that's something else to think about too. And then we don't want to go, we want to know what kind of agricultural crops or products you're growing or raising. So we'd like, you know, we ask that you list that. I mean, and then are you grazing livestock or was it grazed the previous year on livestock? Because we do have a conditional, what we call a conditional year. So if the land was in production and you sell that land to another producer and then that person is going to use it in the same manner, they get that one, what I call a growing season or a production season to show proof that they have the income or the livestock. What we did recently add under the livestock is the MCA and the administrative rules, so people can quickly go out and look to see, does my livestock qualify? And then going on, we ask that if it's, the land is leased to another party, there is a stipulation if it's less than 20 acres, leases cannot be used as income if it's less than 20 acres. Is any other portion of the land used for commercial or industrial use? If it's used for commercial or industrial, it cannot be classified as agricultural. That is broken out. So you can have a commercial storefront and then have your grazing in the back. We will break out that 1 acre or more, depending on how big the commercial is. We'll break that out and then the rest would be then in ag, if it qualified. And then moving down, we asked if it's irrigated, how many acres is irrigated? Are the crops grown how are the crops grown? In the ground, raised beds, self-contained pots, and not applicable. This is really important when we look at specialty crop, which in order to qualify for specialty crops, it has to be grown in the ground. You can't have it in burlap, you can't have it in raised beds. So that's an important question we ask. So we can know just by looking at the application of whether or not they qualify using those parameters. And as we go on to the income section, here is where we're asking what the products that you marketed have, like what have you made off these products? If it's self-consumption, we still want to know. So if you have an irrigated alfalfa field and you're taking that alfalfa for your own livestock, we still want to know how many tons that you're pulling off of there, and then we can determine commodity pricing from that. Self-consumption is not back to your own family. Self-consumption is back to livestock. That used to be a thing. I don't know when they removed it, but human self-consumption was a thing, and they removed it at one point. Was a positive step forward in my opinion. And then we also ask, you know, is your product being stored? Because not everybody sells everything during one season. Not everyone sells it at all. Again, they feed it back to their livestock, so that we want to know that information so we can then give you that benefit back. If it's over 20 acres, we then can look at income from leases and the governmental program payments, and so we ask for that information on the bottom of the income page. And then you flip to page 3 is the family farm section. So family farm is if Robin has a 3,000 acre ranch and Brian's her uncle and he has another 3,000 acre ranch or let's go smaller than that, let's say 40 acre parcel. and you are 10 miles from Robin, but you guys are really, you're using an interval. Robin is moving her cattle to your 10 acres so that they can load them on the trucks, do whatever they need to do, brand them, whatnot. So you're integral. Your parcel alone would qualify for grazing because it's only 40 acres. But because you're an integral part to the family ranch, you can then say, yes, I'm an integral part, I'm part of it, I'm part of the LLC, I'm part of, all, so then you would say, here is the proof that I am part of the family ranch, here's my name on the LLC, and here's how it's all working together. So you can qualify under that. I haven't had a whole lot of people actually do it, but it is an option to get qualified under agricultural. And then the last one is for specialty crop. So specialty crop is a very unique area of agricultural. Most crops we look at on an annual basis. Specialty crop is a crop that goes on year after year after year. There are a whole list of things: fruit orchards, vineyards, Christmas trees, or those are just 3 out of the list of specialty crop. And what's unique about those 3 is that they get 5 years to produce in. So this provisional ag sheet is we need to know how many live trees you have, because there is a minimum. You have to have a minimum of 100 live trees to qualify. We always suggest planting about 10% more, just because some of them will die. And then there's the standard husbandries that we require for those specialty crops. And I will say, because where I live is probably the biggest specialty crop area, our appraisers do a very good job of checking those specialty crop places. They try to get out there on a yearly basis. It's been a little bit harder now that we're now on a 2-year cycle. It's a little harder to find the time. But we do try to make sure that they are spraying, weeding, make sure the fences are up, make sure the trees, gardens, lavender, whatever it may be, is in good condition according to husbandry standards. And if they don't meet those husbandry standards within that 5 years, they can be removed from ag production. So that's a little synopsis of how you would apply to become qualified ag. If anybody has any questions regarding right.
Well, one thing I've always never been quite clear on, and I was curious what your experience is with this. So if someone is removed because they're not taking care of their vineyard or fruit trees, then they can turn that around though within a year and get back to ag status. Okay.
Yeah, and there's been times in my own experience where I've gone out there, and it may be early in the season where they haven't started. I know because they spray and they don't, they spray in a certain time, they prune in a certain time. In my own experience, I've gone out there where it was kind of early in the season and they just haven't started their maintenance yet. So I usually have a conversation with the grower, and 9 times out of 10, you can really tell if they're like legit. So I always say, hey, it's early in the season, I'll be back in a month. Or when do you plan on spraying? And I'll make sure to come back.
You don't have a set standard grace period or like time to.
It's kind of situational.
Yeah.
It really depends.
Right. That's up here.
Since the specialty crop went into statute, and there's fencing and all that stuff now that's in statute. I know some of our appraisers like, hey, by law, you have to have a fence, if it's too far into the season, so like winter, and you're not gonna put a fence post in the ground, we'll give you until, hey, we'll give you until next spring, summer, get a fence up. So I would say that would be really situational.
That's tough for you.
Right.
Gray area there, yeah.
Amanda, why is there not a harvest component as one of the requirements for management of a crop?
Yeah, I've never been asked.
So,
I mean,
Would be an
other,
Income requirement.
Yeah, there's-
Presume you harvest.
but, yeah, after the provisional time, but But I'm thinking that if
Are
you
you talking about specialty crop or just crop?
special,
Okay,
special, because for crop in general, there is
right.
kind of an income component. But
Are you talking about the provisional? So you
Yeah.
have 5 years to get, because fruit orchards, you're
Okay.
not gonna be producing in the first
No.
years from
Mhm.
when you plant the tree.
okay,
So we give them 5 years to become into production, and in the 6th year, they need to provide us their income, their sales receipts.
so if they buy an existing orchard, then they would not fill out this form, they'd fill out a different,
They
a
would still,
different
this
part
is
of,
an
a
application,
different part of this form,
they would still fill out,
the special.
we would still want to know any of this stuff, information.
Okay.
And so if an orchard is like 3 years into new growth, we already know where it's at in its new growth from the time that the first person applied. So if it's a 3 years into new growth and you come and apply and go, hey, I just bought this orchard, do I get my 5 years? No, it's already been in the ground for
Okay,
3.
good,
And
okay,
we can, I mean, we can show proof of that,
All
so.
right.
I just wanted to point out on the family farm section, the likely reason we don't get a lot of those is the income requirements in that column A and B. Because Brian, as my uncle, would have to show that 51% of his income is coming from the family farm. And if my aunt is a school teacher in town, then likely 51% of their household income isn't coming just from the operation. So I think that's the main reason why the family farm section isn't very commonly used as
Mhm.
qualification material.
yeah, that makes sense.
I believe I have had one in the last 12 years.
Just curious, and sorry, you may have said this already, what triggers an in-person review of this, or are you doing it on a, a rotating basis? How are you guys checking that they're not just budgeting?
So in the very perfect world, as an appraiser, personally, because I was an ag appraiser before this, every single application I got, I came and did a boots on the ground inspection. And I mean, there's been one time I've had somebody apply for irrigated hay and I went out there and it was like dirt. So maybe they thought I just would look at the aerial and move on, I'm not sure. But in the perfect world, we're boots on the ground with every single application. There's times where we had somebody trying to grow a vineyard out on a island. Not gonna swim out there every year. So he's submitted like photos to us with a timestamp on the photo of his vineyard. And we've had to use that because again, I mean, we don't get a boat every year either to go out there to make sure he's doing it okay, but. So yeah, boots on the ground for sure.
Okay, every year for every application?
Well, no, not every
As much as
year,
possible.
yeah, so if somebody applies for grazing, if we would go out there and verify the field and make sure that it's, yes, they are actually grazing livestock. Or yes, they're actually irrigating and haying and so whatnot, we may not go back there the very next year. If any inclination that gives us a red flag, whether we're driving by, the neighbor says, hey, like, I don't know why my neighbor's an ag, it's just dirt and you have them as hay, we're probably gonna make a visit.
Okay.
Yeah,
So, sorry, maybe I'm getting ahead of the discussion. So do you all foresee that needing to change if you go to removing the auto qualification every year? Would you need to then be boots on the ground every year for every application?
every application, probably not for every year, again, we don't have the manpower anymore to go out every single year. But certainly with every application, we do our due diligence to make sure and verify that they are, in fact, this is what they applied for, this is what they're doing, so.
Thank you.
Do you have an idea of the amount of resources that the department puts into assessing these properties?
That really depends on the property itself. I can say that some,
I mean, globally, as a whole.
I don't know if globally.
Do we know how many egg apps in general we get annually? Let me see if I can find.
Yeah, I don't know if we have that off the top of our heads.
And it really depends on the year also. I mean, I can say
This year.
a few years ago, I feel like I was getting way more agricultural applications for new than I like we kind of went to a slump, but now that everyone's buying, we're getting a whole influx of new applications again, because if you were to buy my ranch, in order for you to maintain that conditional year, you have to apply. And then show me your production or income the following growing season.
Okay, yes, I would say currently it's not a huge lift because of the auto acreage
Yeah.
qualifications. You get that acreage, so that under 160 that would have to apply, most of those just default into that non-qual status, everything over 160 acres. Other than trying to make sure we've got the use correct on those parcels, it's not currently a heavy lift. Now, that would obviously change, and I think that's one of the items we have later on in the working group session after lunch, is to kind of discuss what a reapplication review process would actually look like, what criteria would trigger, because currently anything under 160 acres, really the main criteria that triggers us to review it and require a new application is a change in ownership. And that's the main trigger right now for us to review these parcels, unless, again, we're picking up new construction next door and our appraiser notices that that field is, the pivot was ripped out and it doesn't look like they're doing anything. Other than that, there isn't a whole lot of criteria currently that triggers a review, unless we just happen to discover a change in use or a change in how the property is currently being utilized.
And me, just in response to your thing on the specialty crops, in the MCA, there's actually one portion that says, following the 5th year provisional ag classification, the property owner shall submit an application for the agricultural classification, then they have to prove their income. Yes.
I can say with all the sales that have occurred, like with this big real estate boom, and all these people the new owners having to apply. I know like in our county right now, we have one ag appraiser in training and one ag appraiser, and for the entire Lake County. And so I know it takes a lot of her man hours to go out to all these applications, because it just because this person was doing it and this person's saying, yeah, I'm gonna continue that, we still wanna verify that that person is in fact continuing that. Because we don't take the ag classification lightly. I mean, you have to, it's a big deal, right? And like, so we do take it very seriously, but it does take a lot of road time from the appraiser for all those applications that we've seen.
Amanda, do you have much cross communication between the local governments at the county level and your office, for instance, about what is being taken out and the zoning questions that might arise?
To be honest, Senator, no. That would be more at there have been meetings. I don't know if Robin's ever been with any of those. I know Scott Williams have been to some meetings with our county officials regarding the impacts of the agricultural stuff. But we don't have we do get permits as long as they're like the new, there's no communication regarding zoning. There's no communication regarding,
And I guess mainly it's because zoning doesn't play a role into
Yeah.
whether or not they classify or not. And so if they're using it agriculturally and they meet these requirements, then we'll classify it as agriculture regardless of zoning.
So, yeah, I will say that like our county has a right to farm ordinance that Wally actually had brought up the last time he was here. So that like a right to farm ordinance states if you have a ranch and I decide to build next to you, I can't complain because it's your right to farm. I can also say like and I can only speak of, I'll just continue to speak of our county. My covenants for my subdivision says that we are not allowed to have any agricultural activity in our subdivision. But if it's not being upheld by the subdivision subcommittee or the homeowners association, if it looks like farm, smells like farm, acts like farm, we're gonna probably classify it as farm as long as they meet the requirements. Regardless of what the subdivision says that they can or cannot do. But if we go in there and somebody applies and says, hey, I got chickens or whatever, and we go in there and we read that it's prohibited, we go in there and no one else has chickens but this one person, I would say that that subdivision's probably upholding their covenants, and we probably wouldn't give it to them.
Not Aubrey County has zoning. So that's also an issue. I mean, if you would think that you'd have to go through an application process and have some level of bureaucracy that's gonna be involved in a transfer of ownership, but not every county has countywide or even outside the town limits, do they have any zoning?
So a developer could take on the heroic assumption that I can go to my local government and set up plans for doing a subdivision, but still at the state level, claim it as agricultural property.
We had that exact case in an MTAB where he had created a subdivision, streets, curb, gutter, utilities, the whole 9 yards was there, but he was still haying it. And because he was still haying it, we had to classify it as ag. We couldn't classify it as suburban tract land.
Even though it was covenanted against ag.
Yes.
That's one of those Three Forks areas deals before they actually put houses on it, right? There were all those curbs and gutters and
Yeah.
streets and things, nothing there but rattlesnakes.
Mhm.
We said, well, hey, this can't be ag land,
Mhm.
because these are these little parcels. It can't be ag land because it's covenanted against it and it's got streets and curbs and gutters.
Mhm.
He was paying all through these little things and said, I'm farming, man. And we took it to court and lost.
Is it because of the income thing or
It was because
because?
he was
Raising or
engaged in farming.
So I was at a conference in Kalispell here sometime back, and we had a presentation by an urban farmer. And he was actually raising grain, it was cropland, and he was talking about running his big equipment around and through that area. But literally was raising wheat and barley, and I mean, it was obviously ag operation. He was leasing all these little parcels. And I guess I don't know if those were considered ag or not. But it would seem like that would meet the criteria if you're leasing that, you own 30 acres.
The trouble
and
with
you got
that is those little parcels, if they're under a different ownership, that becomes the problem. If one person owned multiple, then they would be able to
So
qualify.
that it's not an ag, it's can't, just because you leased it to them for ag purposes doesn't do you any good.
It's got, ownership plays a role in the qualification. And then depending on the size, if they're under 20 acres, that lease agreement they have with the farmer doesn't count because it's under 20 acres, and that's what's in statute currently. If it's over 20 acres, then that lease payment that farmer's making, as long as it's $1,500, could qualify that parcel if that's what its use is.
And another thing at the lease, if they're leasing it out to a grazing operation, it has to be able to meet the AUM requirements first. So you can lease an 80-acre parcel for $3,000 to somebody, but if your 80 acres cannot maintain the minimum animal units that are required, it still won't or qualify for ag.
But if I had 161 1-acre parcels, each under different ownership, it could never be, even if I leased it and farmed all 161 acres, it still can't be
Right.
ag by definition. Does that make sense?
Yes.
Well, since we're kind of on the topic of that provisional status, I was just gonna say that's one thing that can really cause issues, because people can instantly start getting ag status just by planting it under trees.
Right.
And so if they got 5 free years, and I mean, obviously they have to take care of them, but they start weighing that out. And if you're gonna say 15, 20 grand a year for 5 years, I mean, it's pretty easy to.
And I believe at one point they tried to remove the provisional. And just, I personally, I was all for that, because I kind of agree with you, you should, everyone else has to have that income before they qualify, right?
Mhm.
But as an orchard or as, well, specialty crop, because it's not just orchard. Specialty crop gets these 3 items in the specialty crop get this 5-year provisional, so they don't have to have income like everyone else for that first 5 years.
But here's what I wanted to bring up and see if you know some history behind this, because here's kind of the catch is in '89, when we had the big freeze and all the mature cherry producing cherry trees died overnight, that property went from ag to non-ag. And I think that's when they put in this provisional thing. Well, you
Because they had to replant.
She's a historian.
So I don't know if that's when it went in, it was not in the code at that time. It used to be in our administrative rules and had the provisional in there. And it did not specify that it was only for those 3 crops, but it gave things for those 3. We had some cases that went to MTAB for a lot of different reasons. And in the case of that, it was decided that the department had overstepped in some different areas and was making a law through administrative rules, and that we were told we had to take certain things out of rule. So that then came out of rule because it also was something that we had instituted from the department, even though that goes through the public hearing, et cetera. So then it went, the growers came back and requested that go into code. So that was in, I don't know, 2015, I think, is when the decisions were made when we pulled it out. So I think it was the 2017 session when that was actually put in. I'm not positive, but in that point in time. But it was in the administrative rule previous and that came out, but that's probably
So
why.
I'm curious if they lost their trees, they all died, they lose their ag status like right away back then, or, because, I mean, the reason I'm bringing it up is because it almost happened again this winter. I mean,
I do not know if that, at that point in time, I wasn't working it up here as part of the department. I do know that there is another law in code that states that if you do not have income for a year, you have a year to prove that up, but it's only 1 year if you have it from a previous year. So you keep your classification for that year.
Yeah, because that could ruin some of the, especially these days on the lake, lake property.
Yeah.
All of a sudden you went.
With a value of $1,500 an acre to a value of $40,000.
So for that reason,
That'd be.
original status come in handy and be a fair thing, but other than that, it's a big loophole for people.
Some states actually have, but it would be a nightmare to track that with the department. They actually have timeframes, and if you don't prove up through that entire time, you have to go back and pay the taxes as if you had been classified as class 4 during that previous years that you had gotten the agricultural benefit.
We could administer something like that, like, and it's, under the tax term, it's recapture, right? Hey, I got this break for this length of time. I told the state A and I ultimately did B. The state taxes all the time, right? It's recapture. You come back and say, hey, wait a minute, you said you were a cowboy and you're not.
already have
Or
that.
a cherry farmer.
Statute for exempt property, there's
Right.
one piece of exempt property that if it's vacant, they can get 8 years of exemption and they have 8 years to build something on that for nonprofit churches, those type of thing. And if after 8 years they don't do anything with it, we can do that same thing. So that's already in statute in a different case, but it's something that you could piggyback off of.
I will say the one caveat difficulty with that is if the property changes ownership, because the only recourse local government has to collect those taxes, who ultimately do it, is to put a lien on the property. And as soon as that property changes hands, you can't really put a lien on the new owner for something that the previous owner did. So you'd have to build a provision that that's something that's checked at the time of a sale and transfer and would have to be made whole at that point. So that's probably the trickier aspect of that whole thing, is because as soon as it changes ownership, you're getting into a big mess with trying to then back assess unless you collect it and don't allow the transfer to happen and are aware that that exists at that time. Because that's where we've run into a few issues. And there's another portion of statute that talks about missed property that you can go back 10 years, but they have that specific caveat only if it's under the same ownership because of that whole dynamic that the local government treasurers get into with their only recourse is to put a tax lien on that property. And as soon as that changes ownership, now you're getting into some sticky areas.
Title companies might get a little excited about that one.
Yeah.
Amanda, are you aware of what kind of property taxes speaking of nonprofits, do nonprofits actually pay? And
If it
is it
falls
size
under-
dependent?
So like if it's a church.
Yeah.
And that church is sitting on 10 acres and they got their parking lot, the church and their baseball field and everything else is just grass, the part that's not being used is not exempt.
Okay, but there's not like a certain size or anything?
There is certain size for certain types. Is it churches that actually get up to 160 acres?
Don't remember which one.
I think they're limited to 15 acres.
15 acres. There's one of them that can get up to 160 acres exempt, and then the remaining acreage is taxable.
So in the situation of a Hutterite colony who calls itself a church, and they put the school right next to the church, and so they've got a school and a church, then they put all their other buildings around those buildings. How much of that land is part of the church?
The school and the church are the only things that get exempted, and the
Okay.
land underneath them, everything else is taxable on the colony.
Property taxes?
Yeah.
Okay. I was curious. I mean, people ask me all the time, and that's what I tell them, but I'm just verifying that I'm not being full of crap, you know?
What
that kind of girl.
what about the Amish? I've heard this, that, they all claim their house as a church.
No, we actually have quite a few Amish homes up where I live. And the only ones that get the exemption are just like the schools and the churches, and they have to
So it
file
has
for
to
that
be
exemption, just
specific,
like
okay.
everyone else, yeah.
Okay.
What about a wildlife management area? They pay the same tax as any other property owner or fish and game owned property.
I believe some of the fish and wildlife are taxed and some are not.
Correct.
Really? Why would that be?
So fish, wildlife, and park stuff that's exempt is dependent upon the number of acres they own in a county. And if they own over a certain amount of acres, then it's taxable. And then certain parcels that they purchase after a certain date are all taxable. So that's kind of intermixed in code too, what's taxable and what's not on those. And it's not technically taxable. It's exempt, but they have to pay tax as if a private owner owned the land.
It's like a payment in lieu of taxes kind of thing.
Mhm.
But they don't like it when you call it that.
I know.
I know, yeah.
I know, I think I had trouble with fishing game, or legislative auditor for using that word.
What
That's all it feels.
classification does that land fall under?
Depends on the size.
Is it some of it considered ag land?
Yes.
But none of it would be considered residential that I would know of, is it?
No, some of it would be track land though.
Right, okay,
Well, and like the fish and access pieces would be residential
okay.
because they're not commercial either.
How is something like the APR land taxed?
It's taxed as ag. That's kind of been one of the things that's been brought to me by 15 different groups is, but it's being taxed as ag in the first place because by default, it's far greater parcels than the 160.
Mhm.
And then there's more pieces with the APR, right? They have bison.
Mhm.
Bison under Montana law
It's livestock.
is livestock. And I want them kept that way.
Are they showing income from these bison?
They don't need to because it's greater than 160.
Yeah, true. I mean,
But if we
Would it-
eliminate the automatic,
yeah,
They'd have to
Then-
apply.
we're all gonna have to
Right.
eat back at the table at least once in a specified period of time.
Right. So, yeah, and I don't know. I purposely never looked, because I've never had reason to look at their income tax return. But there's gotta be some income there because they're taking eco tours and they're At least there, I think you can go shoot a buffalo if you want, or for a certain amount of money, and
Mhm.
they do lease a lot of grass to a number of different people in different places. At least in Petroleum County, they do. I don't know, they must in Fergus too, don't they?
They lease out property to, to guys to run cattle on. But they're nonprofit on the income tax side of it.
Right.
So they are demonstrating the income off of that, off their leases.
Right. So they would show income at some level. Now, what it is, I don't know, and if you broke it down per acre. But, just knowing it from the map, a lot of those places they bought were not necessarily the biggest deeded acres parcels, but they were the parcels that held the BLM lease in the Russell primarily, right? And so you could buy a 320 and tie up a 20,000 acre BLM allotment in the Russell. And I know, like, the Two Crows, a good example of that. In Petroleum County, it was about 5,000 deeded acres. And there was roughly 55,000 BLM acres in the Russell. So they buy the 5,000 and they've just got 55 for their bison and their turkeys. For our purposes, we'd look at the 5,000 acres and say, well, what are you doing with that, right? Well, you're automatically
Right now.
right now. If we took a minimum, or if we changed it and said, all right, now we're gonna look at whether you're really a cowboy, then we'd have to decide what a minimum is as to whether or not they were really cowboys. And that's the tricky part, right? Because now there's 55,000 acres of buffalo to shoot, but we're gonna have to somehow boil that acreage down to the 5,000, and I'm just using the Two Crows example, right? There's a few devils that live here in these details. And what do? You gotta be a little careful with that, because there are some fair-sized ranches in parts of Montana, especially I'm thinking places like Valley County, Phillips, where there's maybe not such big acres of deeded land and huge chunks of state land and huge chunks of BLM. If we're gonna look at minimums and this person really is a cowboy, are we gonna break it down over their entire operation? Because an outfit with a small acreage, but a big lease, big public lands lease, could be making most of their income off the grass on that, or whatever, on that public lands lease, and not as much off their deeded parcels. How are we gonna, if we're gonna look for a minimum, how do we handle that, right? Because there are some big public land ranches in Montana.
Well, they're obviously attached to some personal property or some
deeded
real,
land.
some real property.
Typically, a BLM requires base acres, so
Right.
you can't just have at least in Montana, you can't just have a BLM lease without a base acre attached to it. Do you know that for sure, John? I think
We
I'm
don't
sure.
have any BLM, no,
There has to be
So I don't-
commensurate properties that has to be tied to.
I
Yeah,
know
base
Forest,
acre.
Forest Service leases are similar to that. You have
Are
to
they?
show a operation site,
So,
not attached, but you have to show a certain site.
Okay,
so it shouldn't be too hard then to connect your operation to what you do on public land. If you own 80 acres, but you use it as part of this operation, it shouldn't be too hard to qualify that as ag land.
right.
We don't currently gather that information, so that would be a new thing that we would have to include as a requirement that they provide that documentation.
Right, all these things would be if we were going to,
Yeah,
prove out that
right.
you're greater than 160 and you're really farming,
Mhm.
right?
Mhm.
Trying to figure out, because the APR comes to mind. They've got, Ross, you know the numbers. How many acres total of public land do they have up there tied up in
I think in the
Fergus?
state of Montana, we're at, I think total they're pushing 600,000, but about a quarter of that is deeded. So something like that.
That they've locked up, I mean that they have control of.
Yeah, that's huge.
Yeah.
So now you've got, all right, so let's say they've got 600,000 total, just for fun, and a quarter of it. And I don't mean to be picking on anybody, they're just an example, right? This is just an example of
It's okay.
what we've got. I know for you it is, not for me. So now you've got this operation that's greater than 160 acres and so now, but we're gonna do it, if we do away with this minimum income thing. And I'm working through this as we go, right? So I'm gonna blunder around. We're only gonna look at the classification of the deeded land, right? We don't touch the BLM or the state, the DNRC lands. All right, so this outfit, whoever they are, has 600,000 acres. They let 50 people come out and shoot a bison for 10 grand a pop or 50 grand a pop. Pick a number, I don't care.
Can I interrupt?
Sure.
Since when is shooting something?
Ag.
Ag income.
Ag
It's
production?
recreational.
Well, but you're
$10,000
shooting a livestock,
Wasn't.
right? They're selling you a cow and you just happen to get to kill it
You get to
yourself.
shoot
It wouldn't
Well,
count
that's what
as
they
the-
did for
It's
Yeah.
their harvest.
That 10,000 wouldn't count because the income has to come from the product that you're producing.
Okay, well, they're producing buffalo. And you just get to
You
harvest
have
your
to
own.
sell the buffalo.
All right, I'm gonna sell it to you and we're gonna name it Fluffy. And then you get to come out and shoot Fluffy. I mean, there's ways around this. Come on, man, I'm a
Yeah.
lawyer.
Yeah. Yeah.
So
Well,
we're gonna
it's-
operate on the assumption that I sold you Fluffy and you just paid me 10 grand to kill it yourself.
But they aren't, I mean, I'll just tell you that their intention is not to make a lot of money off of selling buffalo hunts. So even if you count that as ag production, it's still gotta be divided out amongst 600,000 acres.
Well, does it? Because we don't get to touch the other,
125.
Yeah.
I
right?
don't- I
That's
don't-
the
I mean, I
question
don't
I'm
think-
coming
but I
up
don't
with.
think you get to count production off of 600,000 acres and put all the value on the
150.
150.
Well, that's the question I'm raising. And let's just take it away from shooting Fluffy to I'm leasing John some grass. This organization who shall remain nameless leases John and Brendan some grass and charges us whatever. And they get that money. And let's say it's the only money that they got from leasing grass. Are we going to, when we're deciding whether or not you met a minimum, do we, what's the right word, allocate or amortize that over the 25% of their total holdings, which is only their deeded land? Or when we do this, do we say, oh no, wait a minute, you got $10,000, you have to divide that over 600,000 acres? Can we do that with public land? You see what I'm saying? And we don't need to talk about that company, but we could talk about a rich guy doing the same thing, right?
Yeah, but I think that if the unnamed company is leasing you and John land and you pay him $10,000, that $10,000 should be attached to the land that you actually leased. That it's the land that gets the classification, not the company, really, it's.
Right.
So the classification has to go with the parcel. But the income should also be attached to the parcels. Sometimes I think that we'd be better off if we were able to parcel even some ag properties. So you have 20 acres, but you put 2 acres of it into a cherry orchard. That 2 acres should qualify as your ag, but the other 18 should not necessarily.
Good point. And maybe you answered my question. Maybe I'm just chasing the wrong rabbit here, or Fluffy. Go ahead.
Wouldn't, I mean, when you think about it from an ownership standpoint, just because you're leasing land, you're not gonna be taxed on that. I mean, if I'm leasing your land, you're not gonna say, well, you have 5,000 acres you're leasing. You're gonna say, are you an ag producer based on your land? So the state of Montana or the DNRC or the BLM is already generating revenue basically in lieu of being taxed by having a lease on that land.
You're right. But that's a correct statement. But and I think maybe Cindy answered where I was going, is how do you decide what they leased and what they didn't, or
Yeah, or where the revenue should be attached.
yeah, where the revenue should be attached. And
So the revenue, in my opinion, should be attached to whoever owns it. So if you're leasing it for income, That's how you're proving. I mean, it's no different than a rancher that owns 10,000 acres that doesn't ranch or farm anymore and says, yeah, but I'm leasing it. My income is generated from leasing it, so this qualifies as ag.
Right, but I think it needs to be appointed to the parcels, the acres that are actually producing it, right? I mean, so it isn't, I mean, I think that, I don't disagree. I mean, it's back to, you know, I may not like the unnamed entity's intentions, but as long as they're actually utilizing it for ag production, then it meets the criteria, in my view. Same thing with the folks on the mountaintop. Okay, they bought it, that's fine, but for them to qualify, they still have to keep it in ag, so they need to lease property to John, because you border some of them there, don't you? Close it. But they, you know, they, if they're leasing it to somebody that's engaged in agriculture, then those guys should qualify.
But only that part that they're leasing
It's
to.
not a
Only that
blanket.
part,
Not,
it's not,
not
it's not
100%
everything
of
they
their
have.
holdings, right?
Right.
And if they wanted to lease 100% of their holdings to ranchers in the area,
Right.
let them have their ag classification.
Right, I
ag
mean,
holder.
the, you know, one of the bigger ones up there, he's about 300,000 acres. And, you know, if he leased all but 25,000 of it out, then that should qualify.
Mhm.
If 25 of it he holds just for his hunting,
That should not.
then that should
Correct.
not.
It wouldn't be my upstream neighbor, would it?
I think let's go back to your Fluffy example though, because your $10,000 that you're getting off of Fluffy doesn't count because Fluffy is grazing the land and you have to meet the animal unit month requirements, which I think is one of the main reasons why the animal unit month requirements are there, is to prevent Fluffy's owners in being able to claim the $1,500
Mhm.
in a variety of different scenarios. I mean, you could have prize bulls that you sell, and that's gonna meet $1,500 worth of income too, and you could be doing that on 10 acres. But, so the AUM piece of it, to eliminate it completely is gonna open the door for those scenarios, which is a reason why AUM is in place for grazing.
How does BLM pay taxes? They pay the taxes too?
Yeah.
I don't.
They never-
Well, they do what they want, or, it's kind of, it's the same as Forest Service property.
Yeah.
But yeah, SRS is Forest Service.
And
Yeah.
Filt is BLM.
BLM, oh, okay. I should
Bob,
know
you
that.
have your hand up?
Oh, there's Bob. Go ahead,
Yeah, I
Bob.
do. I do, yeah, that's quite a can of worms when you start dealing with, you know, I mean, you have all these grazing districts out there that are, you know, shared grazing of really public land too, but there's someone that put up a chat here a little while ago that's online that works for the BLM that could probably answer some of these questions, but I think Brendan, didn't somebody up in your neighborhood get in a bind for subleasing their BLM land or something?
Yeah, they're a felon now. But they cheated, right? They got caught cheating. But they were subleasing without paying the surcharge. Because there's a surcharge on BLM land. If I've got the permit, John just can't bring his cows over and pay me a lease. John has to pay me a lease and then he has to pay the BLM a surcharge for having his cows on my lease. My BLM has my brand on record. And this guy was kiting brand inspections to try to tell the BLM that they were his cows when they were really some other guy's cows. And it happened to be on an APR lease. Happened to be on the 2-Crow. And they caught him. And he gets to not own guns anymore.
I don't want to change the subject, but you're talking about, like Ross brought up, shooting the buffalo, and is that ag income? And that question did come up to me amongst some producers, that ag lease or hunting leases have become a huge part of private property income. And is that counted as, you know, if you're the property owner, you have a large hunting lease, is that ag income?
That's domestic.
Livestock. Well, bison, it would be domestic, right? But what you're talking about is, let's just assume your neighbor up there with elk. Now the only income he might have, should he choose, is to sell a few bull elk off the place, right? Is that ag income?
He's not selling elk though, he's selling opportunity.
Right.
Yeah.
But is that ag income?
No.
That would not qualify as ag. All right, so let's
There's a
just,
law against game farms, isn't there?
as long as they're wild. though.
I spent a few days researching game farms, just because somebody brought it up last meeting, so I can answer some of those questions if you need.
Yeah, I didn't think we could have them anymore, actually.
We can't, there are only 16 active game farms in our state right now. You can sell bird farms, just not any livestock game farms.
Was there 16 of them?
There's about 16 active.
Grandfather.
Yeah, so they're
Passed on to
grand.
family members.
Gotcha.
But I didn't think.
A sale of the land doesn't transfer the license, but if you took if the license is in your name and you then transfer the land into an LLC, that transfers because you still own the LLC, so you can still have your game farm.
But okay, so let's say I've got a game farm that I inherited. I don't think you can sell those shoots or anything anymore, right? Is that what, something stopped a bunch of those things, and I
Yeah,
don't
there
remember what.
was an initiative, back in 2000 that stopped the ongoing of game farms, but the current active game farm, there's not a whole lot Fish and Wildlife actually has for regulations on game farms, which is kind of scary, but.
I think the thing they prevented mostly were those small confined operations.
Oh, okay.
The 16, yeah, I didn't see any, the gentleman I spoke to doesn't know of anything like your grandfather. You can run it as a game farm just like as you always have, but once you sell that property, you're shut down. But if you moved your property into a trust or your own LLC, your license goes with you.
So if we've got a 159 acre game farm, what is it in our world? In
Non-qual.
revenue world, non-qual, and they can show income from shooting fluffy,
Unless they meet the AUM requirements.
okay? So, all right, is anybody else as confused as I am on how we treat somebody that shoots fluffy?
We cannot shoot fluffy in qualified.
Okay, solved my problem. All right, so fluffy shooting. So,
I mean, you can probably sell it like, to the, if you need a couple fluffies down, you get a couple neighbor kids and hey, I'll pay you $10.
I think in your country, you can make a living on the shooting bird.
I wish people shoot them for free.
They move a lot more.
So, but there's a question I've got, actually, somebody around here in my shop ought to be able to answer this, right? So bison or livestock? Because, I mean, this is, part of the reason we're sitting here is some of these outfits that are doing this very thing, right? Bison are considered livestock, and I personally in the ag business want to keep them that way. By definition, if I've got a bunch of buffies running around my place, I am raising livestock. Okay, now if I slaughter them and butcher them myself and get income from them.
That's not the raw product though.
As long as you can meet the AUM requirements, you can get.
I'm still good,
Mhm.
okay.
Yeah.
So so my fluffies are all right, as long as I got enough ground to feed
Yeah.
X number of AUs.
So.
And you have to demonstrate sales of it though, too, right? Income as well as AUMs or just?
AUMs, as long as you're meeting those grazing requirements.
So you don't have to sell your cows, you just have to run them.
Right. I mean, I guess if the audit team came forward and said, hey, can we see your sales receipts? I mean.
Because that would be the question on Fluffy.
Right.
Is their intent is not to raise them and sell them.
Right.
Their intent is to let them live free.
So are the egg producers.
Well, ag producers raise, your Fluffy example, to sell.
And so the
Music
AUM
product.
number is based on the notion that that's what it would take to raise $1,500 worth of income that MSU determines each cycle that we do. And so they're taking that $1,500 into consideration when they're determining what that AUM minimum requirement is. And so rather than providing a sales receipt because you sold Fluffy for $10,000, they're already calculating what that $1,500.
And this is all sub 160.
Yeah.
Right?
Yeah.
But now we're talking about injecting the same sort of criteria on
Right.
over 160.
Well, and not all bison producers are just keeping them as a hobby.
Well, most of them don't. It's just
Yeah.
how do you
They're
delineate
treated
the
the same
difference?
as
Livestock.
cattle livestock.
Right.
They're treated the same. The ones that I know in our area, they're just like
Livestock.
raising cattle.
Yeah.
they meet the AUMs, they would definitely meet the income required. If I asked to see sales receipts, they would be able to produce those to me.
But there is a requirement on sales.
There's not a requirement. If you have a livestock and you meet those AUMs, that's where your
Okay, at
requirements
sub
involved.
160, now we're talking about expanding it. Same difference, you could have 100,000 acres as long as you hit the AUMs. You don't have to sell a single critter as long as you hit the AUMs.
Currently, or even if
Well,
we
Connie,
change
you
that.
get-
Over 160 is automatic
Bonnie's
egg.
been
Right,
making
right.
faces.
But assuming we change that.
All right, Bonnie, come on.
Okay, so in the definition of agriculture, it states that it is for a commercial benefit, and therefore you have to be getting an income. And within the code, it talks about marketing a crop. And so in the ag portion for application, it says that you have to be marketing a crop or live. It doesn't say livestock, but to me, that's
A crop.
agriculture. is
Ag
agriculture.
production.
And then it goes on to say that any animal that is a hobby animal, such as a horse, is not considered an agricultural enterprise. So I have told people in the past, since I used to be the sheriff, that you had to show some type of income. We didn't typically ask for that, but if there was a question as to whether or not they were marketing their animal, then they had to show us that. One of our big ones that came across for that was horse farms. A lot of horse farms, they have their horses that they might be boarding them, or they might be training them. Those are not considered an agricultural operation because the land is not producing an animal that they can then sell. So that was where we saw that come out the most. But I have told people in the past, ask them for their receipts, not that it's going to meet the income requirement, but to show that they are marketing an agricultural product from their land. And then we go back to the AUMs for anything that grazes on the land.
So, but now we go to the next step and say, all right, we took away this automatic 160. And now we're gonna have some form of minimum. It's still scaring me. So we're gonna have this some form of minimum. And now we go to this entity that decides to put buffalo out there. And because now we have to decide, I think, how we handle that. Because before, we said they can just run around. As long as I'm 160, I could have feral cows for all that matters. Right? These just happen to be fluffier feral cows. Now we're gonna have to say, you have to show me income from it. All right, so this agritourism, what do we do about that? I'm gonna take you out and I'm gonna let you come and gather up my black cows and trail them around and look like Kevin Costner. And I'm gonna claim that as income. Does that qualify as ag income?
Parks
No.
and Rec.
It's not production.
Okay, so agritourism money won't count. So now I gotta kill something. Right? I either gotta harvest it one way or the other. And old Fluffy's gonna soak up a bullet. So I sell you Fluffy and you get to come out and harvest Fluffy. Is that ag income? You're shooting a cow.
It's your
Makes
land,
sense.
it's your land though,
But I'm
that,
using the land to feed Fluffy that somebody came out and I sold.
Your
and
land
shot.
would qualify first though, right? Is
Yeah.
that what you guys
Does
are
it meet
asking?
the
Like, they're-
AUMs?
yeah, it's gotta
Right.
meet the AUMs. If you just have a patch of, if you have 40 acres and you're running an ag
So
tourism,
what is that?
like, there's a family in St. George, Utah, who has probably 160, and it has city all around it. But it is bona fide agriculture because it harvests a crop, it sells that crop, it has some cattle, and it harvests cattle and it sells meat. You know, it does all of those things. But the commercial side of their endeavor, selling meat, selling entertainment, those aren't part of their ag income, but their crop and their land, the land qualification is what keeps them in agriculture. I mean, that gives them their ag classification. That portion that's dedicated to ag entertainment is basically a commercial operation.
Yeah. So isn't there something to be said for community benefit from ag marketing production? I mean, community benefit
Well,
is not a highfalutin tourist who comes out to shoot Fluffy.
He might spend his time in the Winnet bar. Well,
I mean,
there's,
That's the economy.
I think
Right.
that,
That's
I think that
commercial.
example right there, though, hits it exactly, right? Is they have to qualify that they're actually producing agricultural products that are for sale and so on. All the things that go along with it, you know, that's just being an entrepreneur, right? That you can sell hunts on your prairie dogs you wanna get rid of anyway. That doesn't count towards ag, but it does put money in your pocket, cause most ag people need a little extra money.
But you're only running 5 cows on that 160, so your AWMs will qualify, because you irrigate it, right?
and I'm thinking larger acreage stuff, right?
Yeah.
Yeah,
So,
right.
because we're gonna talk about a minimum in a 160 plus now, so I'm talking
Right.
about something that was a big ranch or a
Mhm.
ranch of over 160.
Mhm.
You know, this outfit that shall remain nameless has a lot of deed land
Right,
and a lot of buffalo running around.
right.
And maybe I am off base here, but I'm worried because those are
Maybe.
livestock.
Right, those are
But I-
livestock.
But I think the point though is it's two things you have to demonstrate that would move forward if we're gonna take away the automatic, right? Is that you meet an AUM standard and you demonstrate that you're producing a product you're selling. And we can argue about whether I mean, I don't think hunting, you know, if I started raising Herefords to hunt, you know, I think people would question that as an income, right? So, I mean, I don't think that qualifies, but those are the things we have to discuss.
I've had a couple I've wanted to shoot. But
Oh, those are Seminoles.
Oh, well.
I hear where you're coming from, and I'm stumbling over this livestock thing and how you arrive at how you got the income, because we're gonna be splitting the hair here over whether or not they sold it to me and I just got to harvest it myself,
Right,
or, I mean, let's face.
Well, a lot of people sell meat on the hoof out of there, right? That's how you
Right.
get around that is
Mhm.
I come and buy the cow, this guy kills it, we take it in and slaughter it, and I mean, to me, that's production.
Right, and so that's what's concerning me, right, is we can have
But
things like that.
it's one thing to sell a cattle or a buffalo, if you will, for consumption. Because there's a reasonable market price that Ross is gonna pay for that cow on the hoof. And then he's also gonna pay somebody to process it. So what a recreational interest pays for the opportunity to hunt far exceeds the market value of that meat. So there's gotta be some reasonableness
Ooh,
if you create an income level.
yeah, but I do not want to be the reasonableness police. On that, on what one of John's cows might be worth versus one of Mark's
Yeah.
buffalo, right?
To me, that's,
We can't do that.
no, we
right?
can't do that, but that's the difference between recreation and
Yeah.
production agriculture. I buy my beef the same way Ross does. I pay my local rancher for a beef, then someone comes and shoots it, and I pay them to process it also, so I have to write 2 checks for 1 beef. But, that's production agriculture. But the opportunity for a recreational experience, that's not agriculture.
I'm with you on that,
Okay.
and I can't, philosophically, I'd agree with you, and, well, we're not the reasonableness police.
Yeah,
And so then we're back to that thing where I started off with,
you don't wanna
our
be
first day
there.
is, we are not gonna decide who's a cowboy or not.
Right.
Or a farmer,
Right,
because we can't,
no,
right?
no.
Go ahead,
I would just, I mean, my opinion is if you're not selling an experience, so you're not taking people on a horse and you're gonna go look at buffalo, that's selling an experience. If you're selling a buffalo and they just get to shoot it, well, it's like, great, maybe the buffalo's worth $20,000, a cow's only worth 1,000. I mean, you can't, I think it's really hard to determine what makes a good egg producer. I mean, they have a commodity that they can sell for more. But at the end of the day, you're getting the same thing. You're getting a dead buffalo that you're gonna take and process versus a cow that you're gonna take and process.
that's what you're on the same page as where I think I was. Chuck, what do you think?
You know, I was actually just looking at APR's tax returns, see what they report for income. And they report about $500,000 of rental income, which I assume is the leases that they're doing, and they report $150,000 in visitation income, which I think is you can go on their site and book a trip to, not for hunting, but to just visit the place.
Rent a year.
It looks like they're not charging
Rent a
anything
year.
for the hunts, for the harvest that they do. They don't refer to their animals as livestock. Under Montana law, they are. They prefer that they be harvested by wolves and grizzly bears, not by humans. I think that's the direction that they're ultimately gonna go. So maybe this, and interestingly, they don't report any unrelated business income, which would be taxable income from the IRS. Everything they report falls under their exempt purpose, which is conservation. So according to what they file with the IRS, they're not in ag production, even on the leased property that they have.
Oh, there's an interesting concept.
You'll schedule it.
Uh-huh.
So how many acres do they show ownership on? And then you said 500,000 in cattle leases or whatever.
Yeah, that's,
So how many acres?
I'm not sure what the acreage is. I think it's roughly what Ross talked about, a couple 100,000 deeded acres.
But
I think,
they would qualify on that leased land that they're leasing because that is currently, as long as it's over 20 acres, that lease payment can qualify you for agricultural land. But if they're not marketing their buffalo, then that would be show us your receipts that you're marketing buffalo, and if that portion of the land then wouldn't be exempt, or wouldn't be ag, if they're not marketing those. But the leased land that they are leasing would actually qualify.
If we put some sort of minimum on, because they automatically qualify now anyway, because
Right.
it's several hundred thousand acres.
Yes.
you know, the part that strikes me is that on one hand, their nonprofit intent is conservation to protect all these lands from overuse by ag production. And yet they're making $500,000 on leasing it out to people to graze on. And they don't have to pay taxes on it because that's conservation. Seems like there's a contradiction there.
There's an income tax issue there.
Yeah.
Different committee, man. But point well taken, right? But, so, I hate to just talk about one entity, but I guess they are nonprofit.
Sorry.
No, it's okay, just, they make an example of what could be more, right?
Yeah.
So you got a couple 100,000 acres and you got, well, let's just make this easy. You got a couple 100,000 acres and you had $600,000 in lease income. That's $30 an acre, right?
Mhm.
Or is that
$3.
three? All right, it's three, sorry. That's why I went to law school. There was no math. So there's $3 an acre.
Mhm.
Maybe that's a little too light,
That's a little too light.
just as, you know, but,
Mhm.
well, and of course, now I bumped their receipts up by 100,000 too, didn't I? Didn't I say, or did I bump it down? I forget what I did. So it's actually less than $3 an acre.
Yeah. No, I was, what he said, 500,000 on a couple, that's $2.50 an acre.
Yeah.
They obviously aren't overstocked.
But, but that goes back to the point of what acres are actually being used for production and what aren't.
Right,
We're doing an
right.
aggregate of 600,000 acres and saying, here's the total dollars.
Right.
But the truth is what leases are you leasing out?
Mhm.
But, I mean, if
And
there's
is it deeded?
20,000 acres here or 50,000 acres there that you're actually leasing out at, maybe you're getting $7, $8, I mean, whatever the number is per acre. And hits it, but the rest of them don't qualify because you're not really using it.
So only those parcels that are being leased for production agriculture should get the ag classification. And all those deeded acres that aren't being leased for production agriculture should not have it.
Well, and I do think it goes back to that point of, we're not here to say who should own it, who's a cowboy and all that. We're just saying that if you have property and it's in production agriculture, even if you're the Wall Street billionaire and you're just hiring local guys to lease it to keep it in ag production, I'm good with that.
Mhm.
I mean, it's the point of saying we really are about trying to encourage food production in the United States, which I do think is an issue. I think the intent of this classification is to encourage ag production, and to try to help make it somewhat profitable. So it really isn't about who owns the land, it's about what land is being used for. So if the nonprofit group is utilizing a percentage of their land in actual bona fide leases to people, for people to run cattle either, or they themselves do it, then they should qualify. And it's not about, to me, it's not about that side of it, it's really about,
Bravo.
yeah, is it production or not?
Bob, you have your hand up?
I do. You know, all this discussion kind of gets back to ag land valuation, and so the way I understand that you value for tax purposes grazing land as capitalized rental income, right? So
Yes.
that- yeah, somebody agree with me or not?
Yeah.
So basically you go through a process where it says, you know, the soil capability, this land is producing X number of pounds of forage and what that's worth and all. So if you're not generating that kind of income off of, if you're not at least generating a landlord share of income off of the land, probably you shouldn't be ag, huh? So someone who's more attuned to how that valuation, especially on grazing land, works. I'm more familiar on cropland, but how that valuation process on grazing land works, and see if there's something there that will get you to what you're struggling to try to find as what qualifies, what kind of income qualifies you.
I think we'll get into that in the next agenda item, as we have TPR has built an Excel spreadsheet with what the Olympic average commodity prices that we use for valuation are to plug in to see what those minimum values would be, or to at least start that discussion. So I think we might somewhat hit on this in the next agenda item.
That sounds like a really good lead into the next agenda. Don't you?
You don't have time before lunch to do that, Bryce.
Just before we change subjects though, last time there was questions about apiaries and chickens and game birds.
Yeah,
And so Amanda put together
just really quick, because I know lunches are around the corner. Yeah, so there was a question in the last meeting about chickens, pheasants, also known as a game bird, and apiaries, and how they fit in this whole agricultural thing. According to ARM 4220-683, these items, along with fruit trees, vineyards, Christmas trees, biological control insects, which controls noxious weeds, gardens, sod farms, horticulture, and nurseries, just to name a few. These all fall under what we call specialty crop. The one unique thing about specialty crop, it does not require 20 acres. It does not require 5 acres. You can have specialty crop on a half an acre. As long as you can market an annual gross income of that minimum required, you can qualify. So there was a question about apiaries specifically, ARM 4220-683, section 3, subsection B, if I'm saying that correctly. The sale of honey and other products from bees is considered agricultural income of the landowner or the landowner's business is registered with the Montana Department of Agriculture. So we don't count how many hives they have, but they have to be registered with the Montana Department of Ag, and it must be the raw product. So you can't, again, you can't sell the honey bears. You can sell the raw honey, but not already ready for store. And then with poultry and game birds, pheasants is a game bird. It gets a little bit trickier. According to ARM, they must be raised in an unconfined area and receive their general dietary requirements from the land. For poultry and game birds raised in a building, a cage, or an enclosed area, that land is not eligible for consideration for agricultural classification. So like if you, the big big barns with all the chickens, that is not considered for ag, that's commercial. So that one's a little trickier to become qualified because not very many people have unconfined chickens for chickens' own safety. You can have a coop for them to go, you know, at night, you can have, you know, during, obviously during the non-grazing areas, you can feed them because it's really hard for a chicken to eat their own snow. Just kind of like you with your own cattle, but it does stipulate that they have to be unconfined. All agricultural land is classified as specialty crop is assigned the highest productivity level of non-irrigated continuously cropped farmland at 60 bushels an acre, which currently comes out to be an assessed value of $1,396.88 per acre. So that's where we're at currently in like this cycle for specialty crop. Yeah, so I just wanted to touch on it because it falls outside of the large cattle, it falls, you know, it falls outside these specialty crop items don't need a lot of space to be.
Where does that number show up?
Which one?
The specialty crop income number.
The 1,000.
The $1,500.
That's not a.
No.
No, yeah, that's an assessed value, yeah,
Okay,
so when
alright.
we run it through our calculations,
Uh-huh.
based on the productivity of the 60 bushels, that's currently on today's cycle, that's what it is valued at per acre.
Those would show up on your assessment notice from us.
Specialty crop.
Right.
It's $358 an acre is the gross income stream. That's for that value.
For specialty crop. All right, thanks.
And Jared's gonna have a bunch
All
of
right,
acres.
all right, okay. Okay.
Do you want to have questions about the apiaries or the game birds? Because I know there was some questions last meeting.
Apiaries, it says it can't be in a confined space, but most of the apiaries that I know that are along the Rocky Mountain front have to protect against grizzly bears.
Apiaries are the bees.
Uh-huh.
So those, they're in their hives.
If I have,
They don't need to be unconfined.
if I have 1,000 turkeys, I'm gonna put a fence around them to protect them from critters who like them for lunch. Well, they're not in a cage, but they're like a corral maybe or something, but you know, but I'm thinking about, there are some pheasant farmers in our area. And they always have they are enclosed because they have netting that protects them from predators larger than they are when they're little, you know, and then they go turn them out in the wild and they get eaten anyway.
In my research, so Fish and Wildlife has the game bird, you can have a game bird farm or license. Fish and Wildlife requires you to have
Okay.
those to be netted
Okay.
and to protect it, because they don't want the wild game birds getting in and they
Yeah.
don't want their domestic or whatever game birds getting out. So
Right.
they have to be
Separated from,
confined.
okay, so does that qualify them as agriculture or not? Not, because they're confined?
Yeah.
Okay,
It's like shooting Fluffy.
yeah,
We're back to Fluffy.
The only time that I mean, very few poultry people qualify just based on, because they usually have them confined to an enclosed little yard.
Right.
If you had 10 chickens, and even on a 1 acre space, it's gonna take, you won't have a yard left.
No, you won't. I
And then
know.
now you're gonna have to subfeed them, so they're not being able to get their dietary supplements now from the land,
land, yeah,
right? I grew up, we had 20 acres and we had about 300 chickens running around on that 300 acres because they would just overpopulate because you couldn't combine them. So,
okay.
so yeah, poultry is really hard to
Yeah,
qualify.
imagine.
Yeah.
You got that one handled.